the court.
Oyez, oyez, oyez. The Honorable
Adjustments of the justice system, social distancing and group size restrictions, as well as substantial hardships on counsel traveling to Austin, do not allow us to hold arguments in the courtroom. Rather than submit cases without argument, we have decided to proceed through remote connections. Court staff and staff from the Office of Court Administration have made every effort to prepare us and counsel, but of course there may be glitches that will require patience. Otherwise, we will proceed as we would in person. The arguments are being live streamed this morning and a recording will be available later today. We're ready to hear argument in cause number PD-0563-19, Casey Allen Martin versus State of Texas. You may proceed.
Thank you. May it please the court, presiding Judge Keller, judges, attorney for the state. My name is Greg Gallion, and I'm a criminal defense attorney out of Dallas, Texas. Together with Lucas Garcia and Michael Mola, we represent Mr. Martin in this appeal. Now, this case originates out of Tarrant County, where pre-trial we filed a motion to suppress alleging an unlawful search and seizure of Mr. Martin's apartment. Now, despite favorable testimony and numerous concessions from the state's witnesses, the trial court denied our motion to suppress. Shortly thereafter, Mr. Martin pled guilty in exchange for 7 years deferred probation, but reserved his right to an appeal. The holding of the lower courts and the issue before this court is that the officer's intrusion into Mr. Martin's apartment did not exceed that of the emergency personnel who were still on the scene. And because of that, Martin suffered no additional injury to his privacy interests due to the officer's entry. Therefore, Officer Hart should be allowed to step into the firefighter's shoes and make the same plain view observations that the firefighter was entitled to make. Now, we are here today asking this court to properly apply the facts from the facts of this case to the relevant law in this matter and find in Mr. Martin's favor. Now, the facts of this case are largely uncontested. On August 30th, 2017, at approximately 10:49, the Bedford Fire Department was dispatched to Mr. Martin's apartment for a fire alarm. When they arrived, they saw Mr. Martin, the only occupant of the apartment, leaving. They went inside and saw a small stovetop fire that they were able to extinguish in less than 2 minutes. They immediately started the ventilating efforts. They started at the front of the apartment and made their way to the back.
Could I stop you right there? You said the facts are uncontested, and you said that Mr. Martin was the only person, but they didn't know that when they first got there. Isn't that correct?
The firefighters?
Yes.
No, they did not know that. Once they began the ventilation efforts, they started in the front of the apartment. And when the firefighters were in there, they saw firearms scattered loosely around. Now, obviously, this caused concern and caused them to move a little bit more safely during the ventilation process. Specifically, firefighter Cook went to the back bedroom of the apartment. And when he looked at the back window, he saw a towel or a blanket covering the back window that was acting as some sort of shade. Went over to pull it down. And when he did so, he knelt on the futon that was directly below it and felt something hard touching his knee. Now, he didn't know what it was at the time, later confirmed that it was an assault type rifle. When he was in that back bedroom, he saw what he thought but could not confirm was drug paraphernalia. Now, all of this coupled together, they decided to call the Bedford Police Department, and they were dispatched at 11:36 p.m., about 50 minutes later. Officer Hart of the Bedford Police Department was the first officer to arrive, and when he got there, he spoke with the battalion chief who was outside Mr. Martin's apartment. The battalion chief told him that the firefighters needed help ventilating, and because of the firearms and what they thought was paraphernalia, they wanted the police there. Now, we can see that up until this point, nothing illegal has happened. It's not until Officer Hart crosses the threshold of Mr. Martin's apartment that the illegal search and ultimately seizure in this case occurs. Now, before Officer Hart enters the apartment, he walks directly by Mr. Martin, doesn't ask for his consent, doesn't have a search warrant. There are no ongoing exigent.
Counsel, before we get into this, I wanted to ask you a question though. Does the search warrant itself refer to observations from the firefighters and the firefighters' observations about drug paraphernalia?
That's a great question. So the search warrant has a 2-sentence mention of what the firefighters saw, but the vast majority of the search warrant is littered with what the police officer saw in their illegal search and seizure.
Okay.
Now, when Officer Hart eventually crosses the threshold with no exigent circumstances going on, he's in the apartment by himself for 2 minutes. He makes his way through all of the rooms in the apartment. And when he comes back out, he grabs another officer. And at its peak, there are 4 to 5 different officers in Mr. Martin's apartment. Now, what they conceded during the motion to suppress hearing is that they started opening up containers, opening up things the firefighters had not done themselves. And to make matters even worse, Officer Versaki arrived well after midnight to again enter Mr. Martin's apartment without any sort of exigent circumstances and search illegally Mr. Martin's apartment. He then later left, used the information that the officers had collected in these illegal searches and applied for a search warrant that was later executed. Now, I believe that in this case, we filed a thorough brief, but I have some points that I would like to focus on during my submission. During the actual motion to suppress, and I was trial court counsel, so I was actually asking Officer Hart these questions in person. He gave 2 legal justifications for his reason in entering Mr. Martin's apartment on that night. The first was a protective sweep, and the second was exigency. Now, this court held in Reeser v. State, and the Supreme Court of the United States held in Bowie v. Maryland, that in a search incident to arrest situation, if the officer has a reasonable belief based on specific articulable facts that someone is inside, armed and dangerous, they can go in to dispel that suspicion. I asked Officer Hart if he had any of those facts, to which he said, quote, "I didn't have any specific information that led me to believe someone might be in there." Now, the state in their brief before this court in the Second Court of Appeals didn't even mention protective sweep. So why did I waste a minute of my limited 20 minutes in discussing it? Well, it's because that was one of the actual legal reasons that Officer Hart articulated during the motion to suppress hearing. The second
Mr.
reason
Gallion?
that yes, Your Honor.
Did Mr. Martin call 911 or do we know who called 911?
It was a water flow alarm. So essentially the water sprinklers triggered the automatic alarm for the fire department to be dispatched.
Can't hear you.
Can you hear me?
I was able to hear you, but I guess Judge Keller was not.
Okay, well, I'll repeat it just in case. It was a water flow alarm system, which is the water sprinklers. And so it automatically triggered the fire department to be dispatched.
Didn't Officer, excuse me, Officer Hart also say that he wanted to make sure there weren't any other threats? So in other words, if there are firearms and ammunition in an apartment that is on fire, couldn't that be a threat?
Well, when Officer Hart arrived, there was no fire. And so there was no ongoing exigency that required his entry. But firearms themselves do not create an exigency. Obviously, firearms, and in this case in particular, Mr. Martin lawfully had all of those firearms. There was no information to suggest otherwise. And so, no, I don't believe that creates an exigency.
I have a question for you. Why is this defendant entitled to require that the officers go get a warrant when firefighters are already in the apartment? They've actually asked, the firefighters have asked the officers to come and help them. And the officers are simply responding to a call for help from other civil servants. And they have then together discovered something that was unlawful going on. And by the way, they did so in an effort to extend help to the defendant, who obviously had gotten himself into some trouble. I mean, there is no constitutional right to commit crime that I'm aware of, nor is there a constitutional right to get away with committing a crime. And so I'm trying to figure out, why would we say under these circumstances that the just thing to do is to require everybody to leave and then go get a warrant when it's already in motion and we already know what's happening here?
Well, the reason is because there was no ongoing exigency that required the police department to enter Mr. Martin's apartment. Now, the problem in this case is that it's not the fact that the firearms didn't create some sort of heightened anxiety for the fire department. Obviously, we would concede that, but it doesn't require an officer to immediately enter. And with a problem for the state when you're applying the facts of this case and what actually happened to the law, Officer Hart, on his own admission, stated that when he went into the apartment, he did absolutely nothing to aid the firefighters. He didn't clear the firearms. He didn't seize the paraphernalia. In fact, he went as far to say that he didn't have a single conversation with the firefighters, anything to the effect of, hey, we've cleared the scene, you're good to go, continue doing what you're doing. So the reason that we don't usurp the Fourth Amendment search warrant requirement in this type of situation is that there was clearly no reason that the officer needed to enter at that time because the firefighters were able to completely do their job. And so when this question is raised, obviously, if there's something going on that requires the immediate assistance of police officers, a bomb, someone inside, something along those lines, I could see why they would allow the officers to come in because there would be exigent circumstances. That doesn't apply in this case.
Counsel, let's assume that the entry by the police officer was not based on some sort of exigency. Isn't your rule, or isn't your holding here, the holding you're asking us to create, just going to lead to the police going, okay, well, if we have to get a warrant, we're just going to ask the firefighters to tell us what they saw? There's no dispute that the firefighters seem to be able to go in here and they saw evidence of drug paraphernalia, which could give rise to a search warrant to search the residence. So I don't see why it is we can't just say, look, even if we strip away everything else in the warrant, we still have the affiant saying that the firefighters saw drug paraphernalia in the house.
Well, the reason that we don't allow that is because under the Fourth Amendment, searches without a warrant are per se unreasonable. And there are delineated exceptions as to why someone can usurp the Fourth Amendment requirement of getting a search warrant in this case. And so it's not up to us to say what makes it more efficient for the police officers or what makes it easier for them. The question is on a case-by-case basis, should the officers have entered? And in this case, the answer is a resounding no.
Okay, well, I'm not saying that we're making it easier for the police officers. I'm just saying that the evidence here was that the firefighters who everyone seems to agree could go in, and there is evidence in the warrant regarding the firefighters' observations. So it does seem like there might have been support in the warrant for the police, in the search warrant for the police to actually enter under the warrant and find the drugs that they ultimately found.
Well, the mention in the search warrant about what the firefighters saw was something along the lines of the firefighters saw what they believed to be paraphernalia. That's it. I don't believe that would have been granted if it were just that. Now, what I can concede, and what should have been done in this case from the jump, was when the police officer arrived, they have a dialogue with the firefighter who's lawfully in there. Hey, what did you see? I saw drug paraphernalia. Tell me a little bit more about what you saw. Okay, great. I'm going to leave one of my officers here at the scene, make sure that Mr. Martin, who there's no evidence was ever trying to actually enter the apartment, I'm going to leave one of the officers here, secure the scene. We're going to go get a search warrant. And I think that if they did what they did in the motion to suppress, where they kind of trump up firefighter Cook's his training and his certifications and that he knew it was paraphernalia, I think in that situation, they would have gotten a warrant. But that's not what they did. It was a single sentence, maybe two, where they just said, the firefighter saw what they thought was paraphernalia. It wasn't enough to get a search warrant.
But, excuse me, you say that the exigency is gone here by the time the police get there.
Oh, Judge, I believe you accidentally muted, or you're muted right now.
Excuse me.
I can't hear you.
Can you hear me now? Can you hear me now?
I can hear you now, yes.
All right, great. I think it's Michigan versus Clifford that says a fire creates an emergency that allows for a warrantless by fire officials. You're saying that the exigency doesn't still exist, but it also says that exigency may exist after the fire is under control to prevent its recurrence and to investigate the cause. And they were still ventilating at the time this was going on. And so it certainly can be argued that the exigency was still in existence when they came in. And as a result, they're in there legally. What is your answer to that?
Well, my answer to that is yes. I believe the case that you're citing, the Supreme Court of the United States case, is directly on track. In fact, we've conceded as much in our brief. The distinguishing part that we're making in this argument is that what allows a firefighter to enter to do firefighter duties is not the same exigency that can be extended to a police officer to allow them to go in and do a full-blown search like the officers did in this case. The exigency must be responded, as this court held in Gutierrez v. State. Whatever the response is to the exigency must be related to the exigency. And so not only is the problem of allowing the police officer to come in without an exigency.
Confused. I'm confused. I thought that firefighter Cook called the police and asked for their assistance to secure the scene. So I don't see where the break is in exigency.
The break in exigency is that everything is always determined on a whether or not there's an exigent circumstance. So is there probable cause to believe that something is occurring? And then did the officer has a reasonable belief that the immediate entry was necessary? And so just the firefighter saying, hey, we need you to come secure the scene cannot pass constitutional muster of allowing a police officer to make a warrantless entry. That's a blanket statement that cannot apply in this case.
I have a question for you. I'm sorry, Judge Hervey. Are you asking?
I'm telling counsel I can't hear him.
Question? Okay. Counsel, Presiding Judge Keller mentioned that she can't hear you. Judge Keller, can you hear her now?
I could hear you, Judge Erie. I could not hear Judge Keller.
I can hear you now, counsel.
Okay. And so back to what we're talking about is, no, I don't believe the same exigency allows for a firefighter if they're, yes.
Well, I wanted to ask you, I think this might be important, and what caused me to think of it was Judge Newell's very good question earlier. And that is, how are we looking, what lens are we looking at this through? This evidence that was admitted was seized pursuant to a warrant, correct? And so what I'm wondering is, you're not, are you complaining about the entry, or are you complaining that the warrant should have been, was illegally obtained and should not have issued to search and seize the contraband that was?
Yeah, great question. So the what we are complaining of is that the officer's illegal entry in Mr. Martin's apartment without exigent circumstances, and then using that information to articulate and put together a search warrant, is the fruit of the poisonous tree. So because they found information, used it in their search warrant in an unlawful manner, obviously those portions cannot stand in the search warrant, and so it's fruit of the poisonous tree. It's directly related to the illegal search of the officers.
And so what we do in a circumstance, Presiding Judge Keller, I'm going to stand down so you can ask a question.
I've been trying to ask a question for a long time, and it's this. The state wants us to adopt a rule that would allow police to step into the shoes of the firefighters. The firefighters, we know, can seize contraband that they see when they're doing their job. This rule would allow the police to seize contraband that they see in plain sight as they're in the shoes of the firefighters. But that's not what happened here. What happened was they didn't seize anything. They went and got a warrant. They went and got a warrant and then prosecuted your client for evidence that they didn't see in plain sight. And I was going to ask the state about this first, but you didn't say time for a vote. I want to see, is there a step that's been missed here between the rule that the state wants us to adopt and the prosecution of your client for an offense, the offense that he was prosecuted?
Yes, precisely. The state continues to point to this majority rule and says that officers can step into the shoes of firefighters, just like you mentioned. But in this case, they didn't step into the shoes on so many fronts. Not only did they not step into the shoes and actually seize the paraphernalia, as other courts have held across the United States, but they also made a search that was much more great than what the firefighters had done. And so, yes, there's a serious problem with allowing the police officers, as they did in this case, or any case, to step into the shoes of the firefighters, especially when they didn't even seize the paraphernalia, which is what the state is trying to get this court to adopt. So the officers didn't do that. And they also went in and had a full-blown search warrant. Yes, Your Honor.
Let me ask you a question. You mentioned this early on. You mentioned that, well, first off, let's assume that the majority of this court thinks that the first officer going in is okay. And then they bring in other officers. You mentioned that these officers started opening containers and stuff. I think that's key. I want to know what you know, because we haven't been able to look at the record. What did they do? Is there any evidence that they actually opened the container when they went in there that contained the drugs or not?
So what they admitted during this motion to suppress hearing was actually on direct examination when the prosecutor was clearly trying to soften the blow of the cross-examination. And the officer admitted that he started opening up containers, opening up ammunition cases, opening up sunglass cases, uncovering additional firearms, doing things that the firefighters had not done themselves. And so what's frustrating is that the lower courts seem to have given the officers a pass and just not mentioned those searches because the methamphetamine making the basis of this case was not found in those containers. So had the meth been found there, obviously they wouldn't be able to make an argument saying there was no greater privacy intrusion when clearly there was. So the officers went in, saw the paraphernalia that firefighter Cook had, and so much more. I see that I'm out of time, unless there are other questions that I need to address at this moment.
Thank you, counsel.
Thank you very much. It's an honor and a privilege to be before you today.
May it please the court. My name is Victoria Oblon. I am an assistant district attorney with Tarrant County representing the state in this case. As I was preparing for argument today and listening to my opposing counsel's argument, I keep being reminded that at the core of a Fourth Amendment analysis ultimately turns on reasonableness. This case presents the question of whether it's reasonable for police officers to enter an apartment during a fire emergency to assist firefighters in handling firearms and handling drug paraphernalia viewed in plain view. In holding that such situation is reasonable, the Fort Worth Court of Appeals adopted the following rule. Law enforcement officers may enter premises to seize contraband that was found in plain view by firefighters or other emergency personnel, at least if the exigency is continuing and the emergency personnel are still lawfully present.
Can I just ask you, counsel, is it your position that they're allowed to go beyond that? In other words, they can go into closed containers and cabinets once they have discovered the contraband weapons created any concern. Not the fire department, but the police officers.
Judge Richardson, yeah. We're having a hard time hearing you.
Let me try this. Is that any better?
Yes.
Nope.
Yes, Judge.
Okay.
Yes.
Is it your position that once the police officers are in the apartment, which doesn't really concern me, and they have the contraband and they see the guns, that without a warrant, they're permitted to continue their search into closed containers and cabinets or anything else?
No, that is not the state's position. And I do believe the Officer Hart did testify at trial. He did do that, admitted that that was a mistake. And that is not what the rule the Fort Worth Court of Appeals adopted would allow, and that's not the state's position. I would like to point out, though, that one, nothing was found in those containers, and that information was not used in the warrant, which is, as numerous judges have pointed out, what was the warrant that was used to
I had one more question.
Yes.
Was this a meth house? Because the stench of meth is usually pretty bad when they went in. Was there any evidence developed that the fire department or the police officers were immediately aware that there was meth being cooked?
There's no evidence of that in the record.
Okay.
No.
Okay.
So following up on Judge Richardson's question, where do you draw the line as to when exigency is over?
Right. I think that's a very good question. And I think that it's very case specific based on the extent of the fire and the extent of the emergency situation that drew emergency personnel to the scene to begin with. In this case, it was a very small fire, but they did need to continue ventilating the apartment. There was smoke throughout. There was no windows in the kitchen where the fire actually occurred, so they needed to enter the other rooms, and they were still in the process of ventilating. In another case, the Idaho court in State v. Bauer, it was a situation where a man was presumably overdosing on drugs and having a heart condition, and he was receiving medical attention by both firefighters and emergency personnel. And the court held that while he was receiving those, the medical procedures in his hotel room, that was the emergency. So that would be determined case by case basis, really using just common sense and how far, what the emergency entails and what's needed by the individual emergency responders in that case.
Counsel,
how urgent was the need to ventilate, given that they seemed not to have been ventilating for a number of hours while the police were coming and going? I mean, really, how long did the exigency last, since ventilation seems to be the exigency and then the emergency need? It didn't seem very urgent. They weren't ventilating.
I think that actually raises a distinction between Officer Hart's initial entry, which occurred very much so while they were still ventilating. When Officer Hart arrived on scene, the battalion chief told him, "My guys can't complete their ventilation process because of what's being in the apartment." And so Officer Hart entered very much in the midst of those ventilating procedures. However, those further officers may or may not have been during the ventilation. To be honest, the record is unclear, I would say, about how long the ventilation procedures actually occurred. However, the lawfulness of those additional officers really turns on whether Officer Hart's entry was lawful. Recently, in Ricks v. State, this court acknowledged that once the privacy of a residence has been lawfully invaded by police officers during an exigency, a warrant is not required for other officers to enter to complete what those officers could have done. In Ricks, there was 2 deceased bodies, a 12-year-old injured child, and a crying baby. There was evidence of the murder of the 2 individuals. And the initial responding officers were there to, they went in and they secured the scene and made sure that the children were okay. And they left. 2 hours later.
Counsel. Excuse me. I need to ask you, as far as the first officer going in, I see no problem with that being an exigency. Once he went in and he checked out the scene, realized there was no other people in there and no likelihood that any evidence is going to be destroyed, how can you come up with going back in there with more officers that's okay? I'd like to see what you think on that.
Yes, Judge, and that's what I was getting to with the Ricks v. State opinion. That first officer was lawful, and Officer Hart said that he did not seize that evidence and things like that because he had to go through his chain of command. He went and asked his supervisor to see if a warrant was necessary. They ended up bringing in narcotics officers to observe to see if a warrant was going to be necessary. And in Ricks, but that doesn't diminish the fact that Officer Hart could have seized those items. He could have gone to get a warrant for further search the apartment. But in Ricks, this court stated that the entry of the second officer did not require a warrant because it merely documents what the first officer had already seen. And again, in Ricks, there was a 2-hour period between when those initial officers arrived responding to an emergency call and when additional officers went in. And what those officers did was they took photos and they collected evidence, all of which was in plain view for those first officers. Very similar to what occurred here, where the officers, the subsequent officers and investigator Versaki came in and observed the same things that both the firefighters and Officer Hart saw when they were initially in the apartment. So,
Counsel,
yes.
Counsel, I wanted to ask you this question because this is actually one of the things that's in the issue. If we go with your rule, does it require us to overrule or essentially create a conflict between our sister court's decision in Talent versus City of Alabama or Abilene?
I do not believe it does. The way that I view that case, I believe that the quote, my opposing counsel, and what's in appellant's brief is dicta to begin with. It really, in that case, they're talking about firefighters' authority to, or the chief of the fire department's authority to require firefighters to submit to a lie detector test regarding criminal issues and not issues related to the job as a firefighter and his duties as a firefighter. And I don't believe that that statement really has any bearing on the overall authority of firefighters and what they can and cannot do.
Okay, well, sorry.
I'm sorry, go ahead, Judge Newell.
Okay, well, the other question I wanted to ask too was, what are we looking at here? What are we focusing on? Are we just focusing on a search warrant and whether or not the search warrant itself establishes probable cause, and how much do we need to take out of that search warrant if we assume bad police behavior? Or are we looking at the initial entry, or are we looking at the prolonged entry? What is it that we're asked here to decide?
As my opposing counsel stated, their argument is that pretty much everything in the search warrant is a fruit of the poisonous tree from that initial entry. As you did point out, Judge Newell, there is information in the search warrant, or your question elicited information that the search warrant does have information from what the firefighter said. It is scant information. My opposing counsel was correct that it does simply state that they believe there's drug paraphernalia, but it also states that there's firearms as well. So,
sure, but in addition to that, though, if we agree with the initial sort of protective sweep, we can also consider what that officer saw in that protective sweep, even if we don't consider the longer or prolonged discussion or search of the residence when ventilation wasn't occurring.
Yes, that is absolutely correct.
And of course, the third thing we're, I guess, asked to look at is the rule. Now, was that a rule you proposed, or was that a rule that the second court came up with on their own?
The Second Court of Appeals came up with it. I wouldn't necessarily say on their own. It has been adopted by numerous jurisdictions in very similar language, if not the exact same language, by courts at both the state and federal level. And I think that I did include it in my brief, and we do suggest it as a rule that this court could adopt, because I think that it really does balance individual privacy interests versus the government's interest in protecting all parts of government agents, firefighters, and the other emergency personnel, and protection of evidence. And that kind of pivots towards I'd like to address appellant's reply brief in this case, in which he argues that this exception in this rule that was crafted by the Fort Worth Court of Appeals really is seeking a generalized fire scene exception, such as the murder scene, that's similar to the murder scene exception that was rejected by the United States Supreme Court in Mincy versus Arizona. In that case, there was a narcotics raid at an apartment, and during the raid, an officer was shot and killed, and the defendant was also shot. There were a few other individuals in the apartment. And so the initial responding officers were there to respond to the shooting scene and that of the like, but because they were part of the same unit as the deceased officer, they removed themselves. And within 10 minutes of those initial officers coming, homicide detectives came and began a search of the house. And it was a 4-day long, unbridled search of the apartment. No warrant was obtained. They opened drawers, they opened cupboards and closets based solely on the fact that a murder had occurred there. And what the rule that the Fort Worth Court of Appeals adopted, and that we propose this court to adopt, it is just nowhere near that extreme. I think that there are two important limitations that the rule the Fort Worth Court of Appeals adopted that set it apart from that and really bring it within Fourth Amendment guidelines. And that is, one, it's limited, the law enforcement search is limited to items observed in plain view by their counterparts, emergency personnel. And two, that there must be an ongoing exigency when the law enforcement officers are there and come into the premise. The Mincy Court, or the United States Supreme Court in Mincy, really noted that individuals retain an expectation of privacy in their homes, even if a crime has occurred there. And likewise, individuals retain an expectation of privacy in their homes when a fire has occurred. The state does not dispute that. However, simply because individual has an expectation of privacy in their home at large does not mean that they retain an expectation of privacy in those areas that the firefighters have already been in and those items that the firefighters have already viewed in plain view. As this court has noted many times, the plain view exception to the warrant requirement really isn't an exception because individuals no longer have an expectation of privacy. The limitations that the rule of the Fort Worth Court of Appeals drafted keeps in mind this overarching privacy of the home in general and limits law enforcement search to things that other government agents have seen in plain view.
Well, the view that the Court of Appeals has set forth is the prevailing view throughout the country. I think the appellant's best case that he has is Hoffman, but that's Ninth Circuit, and it's just not widely accepted. But the one that the Fort Worth Court of Appeals set out is pretty well the law in most jurisdictions, is it not?
That is correct, Judge Kiesler. And even in Hoffman, the court noted that the facts of that case really didn't support adopting such a rule because in that case, there was no evidence of an ongoing exigency when the officer came into the home. I believe it was a trailer home. There was simply no evidence. The firefighters there had already called their station and informed the station that everything was good. Firefighters were going in and out of the premise still, but there was nothing in the record to indicate that there was an ongoing exigency when the firefighters came, which is unlike the present case. When Officer Hart came, he was informed that ventilation was still occurring and that they really could not continue to ventilate the apartment until the police came in and were able to help secure the scene.
While all of this was going on, oh, I'm sorry, go ahead, Judge Keller.
Thank you, Judge. Counsel, I asked opposing counsel about this. Can you hear me?
You're cutting in and out a little bit, but I can overall hear you, yes.
Okay. The rule that you would have us adopt would allow firefighters and police to seize what they see in plain view, at least if they come in during while the exigency is ongoing. That's not what happened here. What happened was they used that information, went and got a search warrant, and then found evidence that they had not seen in plain view. So what I'm wondering is, what is the reasoning behind allowing firefighters or police to see what they see in plain view, and whether that somehow carries over to getting a warrant?
Well, I think that the rule addresses arguments like the one the defendant is making in the present case, that that anything that would be learned from police officers and put in the warrant based on a police officer's observations in a house or after an emergency, that is a fruit of the poisonous tree and cannot be considered. So this rule, it allows that stepstone between what the firefighters see, what the police see, and then being able to use all of that information in a warrant to allow for a further search, which, as you pointed out, is how the evidence in this case and the drugs in this case were ultimately found.
Do any of the cases that you cited, are they all about property that was seized during the exigency that was in plain view, or do any of them involve the police later getting a warrant and coming back?
I do believe that, I'm not 100% sure on my answer for that, so I would have to review my cases and I can submit post-submission answer to that question, Judge Keller.
So would this also extend to, let's say, other emergency personnel?
Yes, I think so. And I think that it rightfully would, because the same interests are at play. If a government agent has already intruded on a individual's privacy, rightfully so, then that expectation of privacy is diminished and would then allow for the police to come in for other instances. I believe I've already spoken a little bit about the State versus Bauer, the Idaho case. In that case, it was EMS and firefighters in conjunction that would allow the police to come in. So, going back to where
just saying, the siren in the background is not my sketchy apartment.
No, that was Fort Worth's finest out there. Sorry. They knew what this case was about.
There's no exigency though, right? There's no exigency.
No exigency in the Tarrant County offices right now, no, that I'm aware of. But going back to where I started this argument, Fourth Amendment core is reasonableness. And I think that the police officers' actions and the firefighters relying on their the brothers in arms, first responders, relying on them to come in and properly observe and document the evidence and then use their observations to obtain a warrant is reasonable in this case. And therefore, the state would ask the court to affirm the Fort Worth Court of Appeals opinion. Thank you for your time.
Thank you very much, counsel. The case is submitted and the court will stand in recess.